share. I think we just showed screen. And then go. And select unpaid dismissal. Gotcha. So I guess this is some questions.
If you have any questions, can you raise your hand? We're just having some issues with the share screen. Please let us know if you can see our shared screen.
Okay. So everybody can hear okay and also see the presentation that's on the screen?
Yes.
Thank you. All right, well, we'll get started. So today's session is on unfair dismissal and the Fair Work Act. And it's just an introduction to the unfair dismissal protections framework. I'm Harriet Murphy. I am a community lawyer here at Darwin Community Legal Service. I would like to start off today by acknowledging the traditional custodians of the land on which we're meeting, the Larrakia people, and pay respects to elders both past and present. I extend that respect to all Aboriginal and Torres Strait Islander people here today, and I acknowledge that sovereignty was never ceded. So just a little bit of information for people who are not already familiar with Darwin Community Legal Service. We're a community legal centre providing free legal and advocacy services to the general public. We're made up of 3 teams: the General Legal Service, which is the team that I work in, and our service areas are Darwin and surrounds. We also have the Tenants Advice Service, which is for tenants of residential tenancies, and they can help Territorians across the territory, and also our Seniors and Disability Rights Service, which is also NT-wide. We also have we run after hours clinics, which are staffed by volunteer lawyers and law students, and we're always looking for new volunteers. So if you want to volunteer with us, please let us know. So today's session, we will be looking at the criteria for unfair dismissal and the legislative provisions and some case law. We'll be looking at the Fair Work Commission process and possible outcomes of an unfair dismissal claim and limitation periods. It's really important to understand that we're not covering general protections, which is a different kind of claim that can be made to the Fair Work Commission, which also involves dismissal. If you're practicing in this area, I do encourage you to do some research on that so that you're across both types of application. But unfortunately, it's just too much to try to fit all into 1 hour. So we're just looking at unfair dismissal today. And the Fair Work Act is federal legislation. So what we're talking about today applies Australia-wide. So we'll start off just looking at the elements of unfair dismissal, which are outlined in sections 383, 385 and 394 of the Fair Work Act. And these are the 5 elements that the Fair Work Commission looks at when they're determining whether someone has been unfairly dismissed. So the first, that the person was employed for the minimum employment period, that the person has been dismissed, the dismissal was harsh, unjust or unreasonable, the dismissal was not consistent with the Small Business Fair Dismissal Code, and the dismissal was not a case of genuine redundancy. So the 4 and 5 are not going to apply to every single case, but they're all important things that the Commission needs to look at when they're determining an unfair dismissal application. So the first element is the minimum employment period. The legislation, the Fair Work Act, says that you have to have worked somewhere for 6 months to be eligible to make an unfair dismissal application. If you were employed by a small business, which has fewer than 15 employees, and that's full-time, part-time and regular casuals, so it doesn't include casuals that are not regular, then in that situation you need to have worked there for 12 months.
Stop you there for a second. We're just being told that we're having some technical difficulties with the screen, so I'm just going to have a look into that, guys. There we go, all fixed. Hope that's better for you.
Great. And yes, the presentation will be available afterwards. So sorry about that. I swear I was reading off these slides. We'll just quickly run through them again. And this was where I was up to. So the first element is the minimum employment period. So 6 months for almost everybody and 12 months for employees of small businesses. You would think it's kind of straightforward, the minimum employment period. You just have to have been there for 6 months. But there can be some complicating factors, particularly when business changes hands. And if it's a franchise, it might keep its name, but it's got a new owner, and often the employee's period of employment might restart. And then also when people have taken extended leave, then that won't count towards the 6 month period. But then it also doesn't mean that there's a break in employment. But so it can be quite complicated, but for most people it's fairly straightforward. You need to have worked there for 6 months or 12 months for a small business employer. And only regular casuals are protected under the unfair dismissal framework. So if you're a casual with irregular hours, then you can't access unfair dismissal. Something that sometimes comes up is people being fired during their probationary period. And probationary periods are relevant somewhat, but the key thing to remember is that the minimum employment period is 6 months. So you might have a 6 month probation period, you get to the end of your 6 months, they extend it to a 9 month probationary period, and then they fire you after 8 months. And people think, oh, well, I was in my probation period, so therefore they can fire me. You can still access the unfair dismissal claim if you've been there for 8 months, even if you were still on your probation period. So the 6 month period is the most important thing. The probation period is relevant to the claim, but it doesn't mean that you can't make a claim. Is that? Yeah, great. So the second element for an unfair dismissal claim is dismissal. And that is defined by the Fair Work Act as when someone's employment has been terminated by their employer, or when a person has resigned but was forced to do so by conduct engaged in by their employer. So that's known as forced resignation or constructive dismissal. What we've seen over time is that employers, I think, consider that it's quite difficult to fire someone who's permanent. So there's been a real shift in, I guess, employment relations, in that now everybody just offers fixed term contracts so that they can just let a contract end and they don't have to offer a further one, and they can't have an unfair dismissal claim made against them. That used to be how employers would kind of try to circumvent the protections offered by the Fair Work Act, but they're now coming under more scrutiny, and we're seeing a bit of shift towards offering protections to workers who have had their contracts end and not being offered a further one. And so in the case that's on the slide, Khayyam and Navitas, Khayyam had been offered successive fixed-term contracts over a period of 4 years, and the Fair Work Commission decided that rather than looking at just the last contract, they needed to look at the whole employment relationship. And they determined that the failure to offer a further contract was actually an action by the employer to end that relationship. So what that means is that sometimes when an employment contract expires and a further one is not offered, that could potentially be determined to be a dismissal, but not every single time. It's something that is still kind of developing, and so it's going to be determined on a case-by-case basis, but it is certainly a shift away from just treating all contract expiries as being unable to be considered as a dismissal. So forced resignation is, as I said, where the employee resigns because they have no choice but to, based on conduct of the employer. In that situation, the onus is on the employee to prove that their resignation was forced, and that they just had no choice but to resign. And it's quite a high bar, and difficult to reach. You can see from these case examples that an employee who resigned after being paid less than 50% of his wages over a period of 4 months, that was found to be forced resignation. He was obviously receiving a really small portion of his wages, and that was deemed to be conduct from the employer that left the employee with no choice but to resign. But conversely, an employee resigned after the employer paid wages a couple of days late, sometimes a bit longer, but usually 1 or 2 days late, and that was not found to be a forced resignation. You can see the difference between the first example, which is obviously really improper to be not paying someone their wages, whereas the second one is probably more of an inconvenience, still improper, but not quite as serious. And so forced resignation is a very high bar that is difficult to overcome. The third element of unfair dismissal is that the dismissal is harsh, unjust, or unreasonable. And you can see on the slide, these are all the all the criteria that the Fair Work Act needs to consider when they're determining whether a dismissal was harsh, unjust, or unreasonable. So they have to take into account everything on there, but some of them are going to be more and less relevant depending on the case and the circumstances. Obviously, whether there's a valid reason relating to the employee's capacity to do the job or conduct whilst on the job, whether the person was notified, whether they were given an opportunity to respond, whether the employer refused to allow a support person. So, you can see that some of these are kind of more related to substance and some are more related to procedure. And these are really the questions that need to be considered when trying to determine whether a dismissal could be found to be an unfair dismissal. Was the dismissal an extreme response? Was the employee, in fact, not guilty of the behaviour that's being used to dismiss them? And is there evidence to support the dismissal? And of course, everything's determined on its own individual facts, and no two cases are ever the same. So what that means is that there's a lot of different ways that a dismissal can be unfair. So there could be substantive unfairness relating to, allegations about the employee's capacity to do the job or conduct whilst performing the job, which might be untrue. But then there can also be procedural unfairness relating to failure to provide notification of the reason and an opportunity to respond, and not giving warnings of unsatisfactory performance. So an example of how that can play out is that is in this case of IGA and Nguyen, where Nguyen, the employee, was involved in a forklift accident And that was accepted by the Fair Work Commission to be a valid reason for dismissal, because presumably it's this serious breach of a work health and safety procedure. But then the dismissal was still found to be harsh, unjust and unreasonable because of the history of the employee's employment with that company, which was 23 years, and the employer characterising it as deliberate when there was no evidence of it being deliberate. So that's an example of when an employee has behaved in a way that does give rise for a reason for dismissal, but then the dismissal in itself is still found to be unfair. The fourth element of unfair dismissal claims is that the dismissal was not consistent with the Small Business Code. This only applies to businesses with fewer than 15 employees. But the Small Business Code permits small business employers to dismiss employees without notice or warning when the employer believes on reasonable grounds that the employee's conduct is sufficiently serious to justify immediate dismissal. And the examples provided in the code are theft, fraud, violence, sexual harassment, or serious breaches of occupational health and safety procedures. So what this means is that if it is not a small business, then a regular-sized business, even if there is these allegations of serious misconduct, they still need to give the employee procedural fairness. So that's usually a situation where the employee might be suspended and not allowed to come to the workplace while an investigation is happening. And there's not really any circumstances where you can immediately dismiss someone in a larger workplace. You need to give them that procedural fairness. Whereas in a smaller business, there is this exception for smaller businesses to dismiss someone immediately. If a claim gets brought in this situation by an employee who is immediately dismissed by their small business employer because of allegations of serious misconduct, the employer needs to show the Commission that they had reasonable grounds to hold the belief that the serious misconduct had occurred. The Commission doesn't actually decide whether or not that was correct, but they need to have reasonable grounds. They need to find that the employer had reasonable grounds. And if the small business employer is dealing with anything other than serious misconduct, they need to follow the same rules as a larger employer, which is that they need to be afforded procedural fairness and given warnings and the like. So the fifth element is that it was not a genuine redundancy. So this is a situation where this would apply to a situation where someone has been made redundant, but they feel that they've actually been dismissed and it's not a genuine redundancy. And redundancies are about the position, they're not about the person. So a genuine redundancy is when the job is no longer required because of changes in the operational requirements of the enterprise. So what that means is that if someone is made redundant, but then the employer gets a new person in to perform that exact same role, then that would arguably not be a genuine redundancy, and that person might be able to make a claim for unfair dismissal. It's also not a genuine redundancy if it would have been reasonable for the person to be redeployed within the enterprise or an enterprise of an associated entity of the employer, which is just a connected business. So the process at the Fair Work Commission is that the applicant or the employee has to file a written application and pay a filing fee. The respondent employer will file a response. There will be a confidential conciliation run by a conciliator from the Fair Work Commission. The conciliations are not an opportunity to file evidence or bring witnesses or argue legal jargon. They're just to try to resolve the matter. And both parties will get an opportunity to speak at the start of the conciliation, and then the parties are separated and the conciliator kind of goes between the parties and provides the other party's offer and tries to resolve the matter. And if the parties reach an agreement, then the conciliator will draft a deed of settlement for the parties to sign, and that obviously includes a waiver of all future claims against the employer. If it does not resolve at the conciliation, which is a compulsory hearing that has to take place before the actual hearing, so if it doesn't resolve at the conciliation, then it will go to a hearing to be heard by a Fair Work Commission member. And there will be a jurisdictional hearing if any of those issues that are on the slide are raised in that particular case, being that the application was filed late, the applicant resigned or was made redundant, or if there is a dispute as to whether they were employed for the minimum period. And a jurisdictional hearing is to determine whether the Fair Work Commission has jurisdiction to hear the case, because the law is very clear that if it's not filed in 21 days and there's no good reason for it to have been filed late, then they don't have jurisdiction to hear it. And if the person wasn't dismissed, then they don't have jurisdiction to hear it. So those usually take place before the conciliation, but it's also kind of up to the Fair Work Commission when they want to list it. And sometimes it can take place after the conciliation, but before the substantial hearing. So the Fair Work Commission has been set up to be very accessible. There's a filing fee of $83. It can be waived if the applicant is facing financial hardship. This filing fee is really low in comparison to a lot of other civil court fees. And most or many applicants are self-represented and lawyers need to seek leave to appear. The Fair Work Commission, when considering whether to give leave to a lawyer to appear, will consider fairness and effectiveness and the complexity of the matter. And fairness being between the parties in the same case. So, if one party is represented, then it follows that it should be fair to let the other party be represented. Effectiveness, if a party is not able to represent themselves for whatever reason, and complexity, whether having a lawyer there would help the matter be dealt with more efficiently. And lawyers do appear at the Fair Work Commission on a regular basis, but it's not a given that they will be given leave to appear. And that is particularly so in cases where one party, usually the employer, is trying to get leave to have a lawyer, but the applicant employee is self-represented, because it can create a really big imbalance between the parties if the resourceful large employer also has a lawyer. But yeah, it's obviously determined on a case-by-case basis. And parties generally bear their own costs. So that differs from other civil court proceedings where it's common for the losing party to be ordered to pay the winning party's costs. Those kinds of orders are not usually made at the Fair Work Commission. So applicants can generally commence proceedings like unfair dismissal claims at the Commission for a relatively low fee without a big risk of being left with a costs order. The Fair Work Commission can make cost orders, and they will do, well, they can do so if the applicant's claim had no reasonable prospects of success or if the claim is vexatious. So there is a risk, but it's generally a pretty low risk. Remedies and outcomes. So at the conciliation stage, the parties are deciding the outcome by agreement. And that can mean that there's just a payment that could be agreed on. Something that a lot of clients also seek at that conciliation phase is asking for the dismissal to be treated as a resignation, so that when they're looking for future employment, they don't have to say that they were dismissed. They're able to say that they were that they resigned, and also a statement of service that confirms that, on the employer's letterhead. So that's a really common outcome that applicants seek at the conciliation stage. And the remedies that are being sought need to be outlined in the application form. So they really do need to be thought about from the very start of the process. At the hearing stage, the Fair Work Commission member obviously decides the outcome. Their first consideration has to be reinstatement. They have to consider that as a first priority, but it is really rarely ordered. That is usually because by the time it's reached a hearing, it's usually many months since that person was dismissed, and the relationship between the employee and the employer has usually completely deteriorated to the point where the employee cannot return to that employer and keep working for them. Their next port of call is compensation, and it's awarded in lieu of reinstatement for losses reasonably attributable to the unfair dismissal. So that's not compensation for pain and suffering or distress or any of those things. The median compensation is 5 to 7 weeks' pay. That is a lot lower than what a lot of people expect. I think that some of the clients that we see here at DCLS expect that they can get a lot more money than that. But that is the median amount of compensation that gets ordered. So it's really important to manage clients' expectations from the start if they are making an unfair dismissal claim. And the cap on compensation is 6 months' pay at the employee's pay rate. So it's always considered relative to the employee's annual salary. So yeah. So when determining compensation after a hearing and a finding of that the dismissal was unfair, and I should also say, it goes without saying that obviously another outcome from the hearing is that the application can be dismissed if the Fair Work Commission finds that there was no unfair dismissal. Then the application gets dismissed, and that's that. But if they do find that the dismissal was unfair, then they will proceed, after deciding that reinstatement is inappropriate, they'll proceed to determining how much compensation that person should get. And these are all the things on the slide that the Fair Work Commission member needs to consider. A really big one is the length of the person's service with the employer. That is going to be directly relevant to how much compensation they get. And all the other matters are also equally relevant. But what I think is particularly relevant is whether the employee has committed any misconduct. So circling back to the ways that an employee can, or the ways that a dismissal can be unfair, if you had an employee who sexually harassed a colleague and they were fired on the spot, the Fair Work Commission might find that there's a valid reason for the dismissal, but they might also find that proper procedure was not followed and the person wasn't given an opportunity to respond to the allegations or given any warnings about it. And so they might find that the dismissal was unfair for that reason, for the lack of procedural fairness. The fact that the employee sexually harassed their colleague is going to be very relevant to any award of compensation. And it is possible that the misconduct might be so serious that the person doesn't get any compensation. So compensation does not automatically follow a finding that you've been unfairly dismissed. And in matters where there's been serious misconduct from the employee, that person might be looking at no compensation at all. Appeals. So applications to appeal an order of the Fair Work Commission need to be filed within 21 days. And the hearing, the initial substantive hearing will be heard by a single member, and then appeals are heard by the appeal bench, which is comprised of 3 members. And they will decide first whether the appellant has leave to appeal and then whether there was an error in the original decision. Further to that, if a party is unhappy with the decision of the appeal bench, they can seek judicial review at the Federal Court of Australia. Obviously, judicial review is not about whether the right decision was made. It's about whether there was an error at law in the decision-making process, whether a matter was taken into account in error or whether something was not taken into account that should have been. And this is where cost orders are probably more likely to come into play. If an employee makes a claim and is unsuccessful and then they appeal that decision to the appeal bench and it doesn't have any merit, then a cost order is probably a bit more likely to happen in the appeal than it is in the initial application. And it is possible that the Fair Work Commission might make a cost order against them only for the cost relating to the appeal and not relating to the original decision. And obviously if a party takes a matter to the Federal Court of Australia, that's a cost jurisdiction. So those cost orders against the losing party are much more common, and it's a very risky move to commence proceedings in the Federal Court of Australia. For the original initial application, there is also a limitation period of 21 days. So that is 21 days from after the dismissal takes effect. So that means the person's last day of work. So they might get dismissed and asked to finish a few days after the dismissal letter or something like that. They might be told they're being dismissed on a Tuesday and finish up at work on the Friday. It's 21 days from the Friday, so their last day at work. Obviously, a lot of people in this situation get dismissed on the spot. So it's from when they were last at work. The period of 21 days can be extended if the Fair Work Commission is satisfied that there are exceptional circumstances, which are the reason for the delay, whether the person first became aware of the dismissal after it had taken effect, any action taken to dispute the dismissal, prejudice to the employer, merits of the application, and fairness as between the person and other persons in a similar position. The Fair Work Commission has made it really clear that ignorance of the time frame is not sufficient to justify an extension. That is something that we come across a lot in our work here, is that people just don't know that they have 21 days to file and they might take a few months to come and see a lawyer, which is really unfortunate, but it's not in itself an acceptable reason for the Fair Work Commission to extend that 21-day time frame. And it is generally, exceptional circumstances is really hard to argue, or it's hard to succeed in arguing it. You know, there are a lot of case examples where applicants have been ill or they've filed in the wrong jurisdiction and they've still not had their timeframes extended. So they're very hard arguments to make. So if you're ever giving advice to someone who's been dismissed, it's crucial that you advise them of that 21-day timeframe so that they're aware and that they don't lose out their opportunity to make a claim. Does anyone have any questions? If you would like to just put them in the chat, or you can, maybe we can work out how to get people to raise their hand, I'm not sure. But I will just say that the Fair Work Commission website has a lot of information on it. It's really, really helpful both for lawyers and for clients. It has bench books with plain language explanations of each of the things that I've just talked about, along with all of the general protections claims. So I would highly recommend utilising that resource and also directing clients to it as well, because it is written in, as I said, in plain English, so it is really accessible for members of the public who might want to know more about their rights if they have been dismissed or they think that they're going to be dismissed. No questions? All right, well, it seems like there's no questions. So we will just finish up a little bit early. If anyone does have any questions, Sarah's just put her email address or like our info email address in chat. So you can send any emails through to that, or to any questions or queries through to that email address if you would prefer. And we will be sending the slides around, and also the recording will also be sent around in, I think, a few days.
Yeah. Take a couple of days, we're just gonna get the recording, make sure it's all good and send it all out to you.
Great, well, thank you everybody for coming. I hope that was helpful. Everyone, enjoy your early lunch.
Thank you.
No worries.